Thank you everyone for joining us today. We're going to give everyone one more minute to get online and then we will get going with the webinar. All right, we're going to get started then. Thank you everyone for joining us today. This is the NIJC Part 1 Asylum Pro Bono Training. We really appreciate everybody for jumping online. This is our first time we've done a full asylum virtual training, and we've split it up into two parts. So today we'll be talking about the basics of asylum law, and then on Wednesday we'll be talking about the nuts and bolts of how you put together your case and present your case at the asylum office or the immigration court. So with me today is my colleague Dahlia, who will be participating in the second part of the training today. Dahlia and I, along with our colleagues Rachel and Anna, make up the Asylum Pro Bono team at NIJC, and we are the ones who provide support to all of you when you handle cases through NIJC. Before we get started today, a few housekeeping matters. So in the handouts portion of the webinar here, you will be able to upload or download an agenda for today, a copy of today's PowerPoint, and a tools for pro bono attorneys document, a one-page document that gives all the basic information you need to know if you're representing an asylum seeker. We will also be able to answer questions throughout the training today. If you have any questions, please put them in the Q&A section, not in the chat section, please, but the Q&A section, so we can chat your questions and we will try to answer throughout all we can. We may not be able to get to some questions to the end, and some questions we may just respond to you directly if it's not something we can answer during the training today. Finally, as you've signed up for the webinar today, you know that if you do not currently have a case with NIJC, we do ask that you take a case within 3 months of attending this training. If you're interested in taking a case, we'll be circulating a case list sometime later this week after both of the trainings are complete. So we are now going to move forward. And again, if you have any questions, please don't hesitate to ask them in the Q&A box of the webinar software. So before we get into the substance of the training, a little background about NIJC. So NIJC is a legal service provider organization. We're based in Chicago, but we have offices in San Diego, Indiana, and Washington, D.C. We serve about 10,000 non-citizens each year. And we do this primarily through our network of pro bono attorneys like you all who are participating in the training today. What makes NIJC unique among immigration legal service providers is that we do both high volume direct representation and also high volume impact litigation, policy, and advocacy work. And we think this is really critical to our mission and to the work that we do, because we're able to leverage and be informed by the experiences of the clients that we represent and work with to inform our policy, education, and litigation goals. And this has become very critical nowadays as we are dealing with so many changes in the immigration system, and we are able to determine what are the issues that are facing our clients, what are the primary issues that are important to them, and then use those as we engage with members of Congress, as we engage in impact litigation and move forward to try to make changes in the immigration system. At NIJC, we do have a number of pro bono programs in addition to our asylum program that we'll talk about mostly today. We also have a number of different programs ranging from providing pro bono representation to individuals who are seeking citizenship, to asylees and refugees who are petitioning for family members, to children who are seeking something called special immigrant juvenile status, and to VAWA and U visa, which is forms of relief for survivors of domestic violence and other violent crimes. So in addition to taking on an asylum case today, if you have an interest in getting involved in any other NIJC matters in the future, please don't hesitate to reach out to us. Information on how to contact us, again, is in our materials and the handouts and at the end of the slides today. We like to spend a little time at the beginning of the training talking about how clients come to NIJC and how in turn they get to you if you take a case through us. We find that this is particularly important because a lot of times by the time an asylum seeker comes to you for representation, they've already worked with numerous individuals, and it can be both confusing and complicated to understand your role versus our role versus the role of other individuals that they've interacted with during their time in the immigration court system or the asylum office system. So what typically happens is an asylum seeker will contact NIJC and say that they would like representation in their asylum case. We get referrals from a wide range of sources. We work closely with community organizations, religious-based organizations, schools, hospitals, social service providers, a number of different entities in the community who refer clients to us who need representation. Once a client comes to us and says, you know, I am afraid to go back to my home country or I want to seek asylum, we conduct an in-depth legal screening of their case to determine if they're eligible for relief, to determine if we think they meet our income eligibility criteria, to ensure that we think providing them with representation would be a good use of our pro bono resources, understanding that pro bono resources are limited. If we accept the case for representation, then we will put the case on our pro bono case list that I mentioned earlier, and we will then circulate that to our pro bono network. If you like to take a case from us, then we will send you the information to run your conflicts check. And then once you accept the case, it is yours. You're the primary attorney of record. You are the one going to court or the asylum office, preparing the full filing, but we are here every step of the way, and we recognize that you are most likely not an immigration attorney and may have very limited immigration experience before handling this matter. And so our goal is to ensure that you feel supported and have the best possible chance of a successful outcome for your client. So we provide a number of different resources that we'll be talking about today that can help you ensure you can get that positive outcome in your case. One of the most important things, however, to ensure or help ensure that an asylum seeker can have a positive outcome is having an attorney. Non-citizens in deportation proceedings do not have the right to appointed counsel. They have the privilege of representation, but at no cost to the government. And that means for the vast majority of non-citizens and asylum seekers who come to NIJC requesting representation, if we are not able to provide them with pro bono representation, they are very likely to have to go forward pro se. And it is much, much more difficult for a pro se asylum seeker to obtain protection. As you'll hear about today as we talk through the law, asylum law is incredibly complex, and the procedure has only grown more complicated during the past few years. It is very difficult to envision a way for most pro se asylum seekers to be successful in their case, particularly before the immigration court, given the numerous barriers that have been put into place nowadays. So as a pro bono attorney, you can make an incredible difference in the life of an asylum seeker who has a viable claim for relief, but simply needs an attorney to work with him or work with her to get to the finish line. Here in the Seventh Circuit in Chicago, pro bono attorneys have made a tremendous difference in helping preserve and maintain good case law for asylum seekers. The Seventh Circuit is one of the best places to seek asylum right now in the United States. And one of the primary reasons for that is that again and again, we have had pro bono attorneys who've been able to prepare strong records in support of their clients' claims, and if unsuccessful, have litigated those cases up to the Seventh Circuit and created and preserved positive case law. When you look back at many of the positive precedent decisions from the Seventh Circuit that have come out in the past 5 or 10 years, a significant portion of those have come from cases handled by NIJC pro bono attorneys. So although it's not typical for an NIJC pro bono asylum case to go all the way up to the Seventh Circuit, when they do, we have a very strong track record of creating good case law and preserving the good case law that already existed. The final thing to keep in mind is the importance of what you do also for other asylum seekers when you accept a case from NIJC. NIJC, as I mentioned earlier, we accept cases for representation after we do our intake before we know whether a pro bono attorney will be able to take a case. And that means if we are not able to place a case with pro bono counsel, we will handle that case in-house. But that means we need to ensure that we have the capacity to handle every single case we accept. And so when we have too many cases on our pro bono case list, that means we can't move forward with other cases until we're able to place one with a pro bono attorney. So every single time you accept a pro bono asylum case from NIJC, you are opening up space for another asylum seeker to obtain pro bono representation. You are also helping ensure family unity. When an asylum seeker gets asylum, they are able to petition for their spouse and children to get derivative asylum status. So you are not only helping the one individual you might represent, you are ensuring that that asylum seeker is able to stay with their family or to petition for their family to come to the United States and ensure that family unity. All right. We're going to go forward now into the nuts and bolts of asylum law. So before we get started, a little bit about the cases we're going to talk about today. So I, Ashley Huebner at NIJC, oversee our asylum and kids programs. And we see clients seeking asylum from all over the country, all over the world, I should say. And many of our clients nowadays, however, are coming from Central America and Mexico, and they often have claims that are very similar in fact pattern and very consistent with the country condition evidence that we are seeing from those parts of the world. And one thing that we always like to emphasize when our pro bono attorneys are taking cases from us is that we don't want you to have to reinvent the wheel. And unfortunately, because so many of our clients are fleeing the same types of harm from the same countries, we have a lot of great resources that you can utilize. But you also likely have a lot of great resources within your firm. And so we're going to talk about cases today that are not, they're not factual cases and that they are based on one individual client, but they are based on the combination of numerous client stories we've heard over the years, and they may sound familiar to you for that reason. So if you are hearing similar facts that we're talking about today, that's because there are many other asylum seekers like your client that have similar fact patterns. And there may be others in your firm that have similar fact patterns. And so we want to make sure that you are able to leverage the experience at NIJC, the resources that we have, and the resources from within your own firm. And we're happy to help you do that as you move forward. So before we move into the actual law itself, we're going to start with two hypotheticals. These, again, are not real clients that NIJC has, but these stories are very familiar to NIJC because these are fact patterns we see quite frequently among clients that come to us seeking representation. So we're going to take a few minutes for you all to read these two hypotheticals, and then we're going to do a quick poll for you all to respond as to whether you think these asylum seekers right now at the beginning of the training would have viable claims. So we'll give you about 1 minute to read through, and then we'll do the poll. Okay, we're going to start the poll now. Please take a few minutes to answer the poll, and then we'll share the results. Okay, about 10 more seconds. All right, we're closing the poll, and we'll share the results. Okay, so about 36% thought that Cristopher was the only one here with a viable claim. About 5% thought that only Norma has a viable claim. And about 59% said that both Cristopher and Norma had a viable claim. And so from NIJC's view, again, based only on the facts that are here in the PowerPoint, our position would be that based on these facts, both Cristopher and Norma do have a viable claim for asylum. And so we're going to talk about how they would fit within the asylum standard and what we would do to look at their claim and to present their claim moving forward. All right. So asylum law is based on an international definition. It's based on the international definition of a refugee. In order to establish your eligibility for asylum, you have to prove that you are a refugee. The difference between an asylee and a refugee is that a refugee is somebody who has met this definition outside of the United States and comes into the United States with the lawful status of a refugee. An asylum seeker, on the other hand, is somebody who's physically present in the United States. No matter how they entered the country, they are physically present in the United States, and they have to prove while here in the United States that they meet this definition of being outside of their country of nationality and unable or unwilling to return to or go back to that country because of a well-founded fear of persecution on account of their race, religion, nationality, membership in a particular social group, or political opinion. So this international definition is codified in US law, the Immigration and Nationality Act, and the US Code. And this is what the entire asylum case and claim will be based on. So we're going to break this down in a little bit and talk about how we meet this definition and each part of this definition in the two cases that you just saw in the hypothetical. So this definition and asylum law is found in the Immigration and Nationality Act, as I mentioned, but asylum law, like all immigration law, is administrative law. And so we rely heavily on the federal regulations, which have been changing quite a bit under this administration. There have been numerous changes made to or attempted to be made to the regulations as they affect asylum seekers. We also look closely to case law. Many aspects of the definition are not defined in the statute or the regulations, and so we have to look to case law to determine what various parts of that refugee definition mean. As I mentioned before, the Seventh Circuit is one of the best places to practice asylum law right now, and so we really want to look closely to Seventh Circuit law. We also have to look to the Board of Immigration Appeals. In the immigration court system, the Board of Immigration Appeals is the administrative appeals level. After you go to the immigration court, you would go up to the Board of Immigration Appeals. BIA case law is binding on all immigration courts in the United States, unless the particular circuit in which you practice, the circuit court has overruled that board case law. So for example, if the Board of Immigration Appeals issues a decision and the Seventh Circuit overrules or declines to defer to that particular board decision, then that decision is not binding here in the Chicago Immigration Court, but would be binding everywhere else in the United States. This is really critical to keep in mind because the Seventh Circuit has declined to defer or has overruled many Board of Immigration Appeals decisions, particularly when it comes to asylum law. And there is somewhat of a circuit split when it comes to which Board of Immigration Appeals case law applies across the country, with the Seventh Circuit right now coming down on generally a very positive side of things. And so although you want to be aware of what the Board of Immigration Appeals case law is, the Seventh Circuit case law is generally where you want to pay your attention to. And for the same reason, you don't want to look outside of the Seventh Circuit. Because Seventh Circuit case law is so good, and generally there's quite a lot of it that is relevant to asylum claims, if you cite to circuits outside of the Seventh Circuit generally, an immigration judge is either going to think you don't know what you're doing, or that the case law must be pretty bad in the Seventh Circuit if you have to look elsewhere. So when you're looking at your claim, when you're briefing your case, you really want to stick to Seventh Circuit case law most of the time. All right, we are going to talk about really quickly two other forms of protection-based relief besides asylum. One is called withholding of removal, and one is called relief under the Convention Against Torture. And this is because sometimes individuals are not statutorily eligible for asylum or withholding of removal. Sorry, they're not statutorily eligible for asylum and sometimes not eligible for withholding of removal, and they need to seek these other forms of protection-based relief as well. We're going to talk about these very briefly. The bulk of this information is all found in our asylum manual if you're interested in more details about this. If you have a client who may not be eligible for asylum, this is something we would discuss with you specifically in your individual case. So when you seek asylum, you are automatically seeking another form of relief called withholding of removal. Withholding of removal is basically what it sounds. Your removal is being withheld to the country where you fear persecution. So you cannot be deported to the country where you're afraid you're going to be persecuted, but that is it. You don't get all the benefits of asylum that we'll talk about in a little bit. So the definition for withholding is very similar to the definition of asylum, but the burden of proof is higher. It's a more likely than not burden of proof rather than the reasonable possibility burden of proof that we have in asylum. And we'll talk a little bit more about that in a second. But otherwise, you'll recognize that this definition looks very similar to the asylum definition in that it's talking about somebody who's afraid they're going to be harmed or killed because of these 5 protected grounds. The other form of protection-based relief is called relief under the Convention Against Torture. CAT relief is a little different than asylum and withholding of removal, and it is generally something we request also at the same time we request asylum. So you are typically going to request asylum, withholding of removal, and relief under the Convention Against Torture in every single protection-based case you have. Convention Against Torture relief, like withholding of removal, has a more likely than not burden of proof. So it has a higher burden of proof than asylum. And similar to withholding of removal, all it does is it withholds your removal or defers your removal to the country where you fear you're going to be tortured with no other benefits. And again, we'll talk about those benefits in a second. Unlike withholding of removal, CAT relief also has a different definition than asylum. Here we're talking about torture rather than persecution, and we are not having to worry about those 5 protected grounds that we mentioned for withholding and asylum relief. But CAT relief requires more governmental involvement. In order to get CAT protection, you have to show either that the torture was or will be by the government, or that it would be with the acquiescence of the government. And this is a higher standard of proof than we have for asylum and withholding of removal, which refers to the government being unable or unwilling to control the persecutors. And again, we'll talk about that standard a little bit more later. Now, like I said, the reason you would be seeking withholding of removal or Convention Against Torture relief generally is if your client is ineligible for asylum. So asylum is a discretionary form of relief. If you meet all of those elements in the definition, but the judge determines that as a matter of discretion, he or she does not think your client merits asylum, then the judge could deny asylum. Withholding of removal and CAT relief, by contrast, are not discretionary forms of relief. As I mentioned, asylum has a reasonable possibility burden of proof, meaning you only have to show that at least a 10% chance exists that your client will be persecuted in the future. Withholding of removal and CAT relief have a more likely than not burden of proof. Asylum, however, has many, many, many more benefits than withholding and CAT relief. So again, withholding of removal and Convention Against Torture relief simply prevent your client from being deported to the country where he or she fears they will be persecuted or tortured. Asylum allows you to permanently gain status in the United States. Once you have asylum, you are eligible to apply for residency or a green card within 1 year, and 5 years later, you can apply for citizenship. As I mentioned earlier, you can petition for your spouse and children to get derivative status through you, and you can travel abroad, not back to your home country, of course, but to other countries. You become eligible for things like federal financial aid, which can be very critical if you're a young person who wishes to go to college. Many, many other benefits as an asylum seeker that lead you to having permanent status as a citizen in the United States. Withholding of removal and Convention Against Torture relief simply don't give you those benefits. But for some of our clients, they are the best form of relief they can obtain, and it still prevents their removal to a country where they'll be persecuted or tortured. All right. So again, we seek withholding of removal and Convention Against Torture relief in nearly every case of asylum that we're presenting. Today, we're going to focus primarily on asylum, though, because this is the bulk and the primary form of relief that the bulk of our clients will be seeking. So we previously talked about that definition, which I'm just going to go back to very quickly here. So this is the international definition of a refugee. And again, as I mentioned, this is what our entire claim is going to be based on. So we like to break this refugee definition into 5 elements, and that is what the case is based on. This is what your brief will be based on, your client's affidavit will be based on, your arguments in court will be based on these 5 definitions. So that international definition is broken down into these 5 elements of well-founded fear of persecution perpetrated by the government or an entity the government is unable or unwilling to control on account of one of the 5 protected grounds: race, religion, nationality, membership in a particular social group, or political opinion. These elements are all separate, and this is very important to keep in mind. We often see erroneous decisions from immigration judges, the Board of Immigration Appeals, and sometimes the Court of Appeals, where they deny asylum in part because they have conflated these elements together. So for example, a judge might say, you haven't shown that you belong to a particular social group because you haven't proven to me that you were persecuted on account of your social group membership. That's conflating the question of whether the client was persecuted with the on account of element, why the client was persecuted, with the question of whether the client belongs to a protected ground. So for example, the Seventh Circuit, despite much of their good case law, has one decision in which they say rape is persecution if it's inflicted on account of a protected ground. So that again conflates the question of whether rape is persecution, whether the persecution was inflicted on account of a protected ground, and whether the client belongs to a protected ground and the persecution was inflicted for that reason. The proper argument would say rape is persecution because of the type of harm it is and the harm it causes to the survivor. Whether the person gets asylum based on that form of persecution depends on whether the persecution was inflicted on account of a protected ground. Generally, we would say that in most cases, rape is being inflicted if it's being inflicted on a woman because of her gender. It's an inherently gender-based form of relief. And therefore, if gender and nationality could be a particular social group, and we'll talk more about that in a bit, then rape could be a basis for asylum depending on those particular facts. And that's the way you'd want to present the case. Persecution is separate from on account of, which is separate from the protected ground. So we're going to walk through these 5 elements that we just talked about. So the first, again, is well-founded fear. Well-founded fear in asylum is the burden of proof. And as I mentioned before, well-founded fear has been determined by the Supreme Court to constitute a reasonable possibility burden of proof, which is a 1 in 10 chance of persecution. So in order to establish that your client is eligible for asylum, you only have to show that there's a 10% chance that your client will be persecuted in the future on account of a protected ground by the government or an entity the government is unable or unwilling to control. But what's tricky about this, of course, is that you have to show a 10% chance of something that has not happened yet. And that's where these cases get particularly challenging. Fortunately, the regulations say that you can establish a well-founded fear in one of 2 ways. First, by establishing all of the elements as to past persecution. So past persecution on account of a protected ground by the government or an entity the government is unable or unwilling to control. Or you can establish a well-founded fear by showing a reasonable possibility, a 10% chance, that all of the elements will happen in the future. So a 10% chance that in the future, your client will suffer harm rising to the level of persecution on account of a protected ground by the government or an entity the government is unable or unwilling to control. Because there are these 2 ways to establish asylum eligibility, you generally want to argue both whenever you can. You have to meet the future fear claim. You have to show the well-founded fear of future persecution. But if there's any chance that you can establish past persecution as well, you want to make that argument. And the reason for this is because under the regulations, if you've established past persecution with all of the elements, you get a rebuttable presumption of future persecution. So you are nearly to the finish line. At that point, the only way you wouldn't get asylum is if the government can rebut that future persecution by either showing a change in circumstances so that you no longer have that well-founded fear, or by showing that your client could safely and reasonably internally relocate within your client's country. If the government cannot show that, then the presumed future fear of persecution has not been rebutted. Now, sometimes we do have clients who managed to leave their country before past persecution happened, or before the past persecution became severe enough to rise to the level of persecution. And that's okay. They can still be eligible for asylum as well. So to establish asylum eligibility based on a future fear of persecution, you have to show 2 things: a subjectively genuine fear of persecution. So generally speaking, this means that your client is credible and has a genuine fear. And you have to show an objectively reasonable fear. The objectively reasonable fear is where the burden of proof, the reasonable possibility, comes into play. So you have to show, to meet the objectively reasonable standard, at least a 10% chance that your client will be persecuted in the future on account of a protected ground by the government or an entity the government is unable or unwilling to control. If you have a future fear claim the burden is on you to also show that your client cannot safely or reasonably internally relocate within your client's country. Remember, if you've established a past persecution claim, the burden is on the government to show that relocation is safe and reasonable. If it's a future persecution claim only, then the burden is on you. And because of the way we often present these cases, you typically want to make arguments regarding internal relocation, even if you think you have a good past persecution claim, because you never know how things are going to come out. If you meet all this in the future, even not having suffered any past persecution, then you would also be eligible for asylum in the United States. There's one other way that an adjudicator can grant asylum if an asylum seeker has established past persecution with all the elements, but the future fear has been rebutted. And this is called asylum on a humanitarian basis. So if your client has suffered past persecution with all of the elements, but for some reason the future fear is rebutted, either because of change in circumstances or because your client could safely or reasonably relocate, the adjudicator can still grant asylum if your client could prove that the past persecution was so severe your client should not be compelled to return, or if your client could prove that there's a reasonable possibility that he or she will suffer other serious harm in the home country. So to break these down a little bit, the severity of the past persecution prong here is a pretty high standard. One of the first cases to talk about asylum on a humanitarian basis was a case called Matter of Chen. And in that particular case, it involved a man who he and his family had lived through the Cultural Revolution in China and experienced horrific forms of abuse that continued to psychologically impact the asylum seeker to that time. And based on those facts, the Board of Immigration Appeals found that this severity of past persecution prong had been met. So it's a high standard, but we definitely have clients who unfortunately have experienced that level of harm and could potentially have an asylum on a humanitarian basis claim based on that prong. Generally speaking, it's a little easier to meet the second prong, the possibility of other serious harm. To keep in mind here is the other serious harm needs to rise to the level of persecution. However, there's no nexus requirement here. So you don't have to show that that reasonable possibility of other serious harm was on account of a protected ground. And the case law in a decision called Matter of LS and others talks about the various types of harm that could be considered for this humanitarian asylum basis. It could be a client who's returning to a war-torn country where there's a reasonable possibility that he or she will be harmed for that reason. It could be a client who's in need of medical care or mental health care and will not be able to obtain that mental health care or medical care in home country. And that the consequences of that would constitute an other serious harm. So these are very important things to keep in mind. We generally advocate making an asylum on a humanitarian basis claim in every single asylum claim we have, so long as there's past persecution that can be argued as well. All right, so we're going to move into the second element here, which is persecution. So persecution is a term that's not defined in the statute or regulations, so you have to look to case law. Fortunately, here in the Seventh Circuit, we have very good case law describing what could constitute persecution. The primary case we recommend you look at is a case called Stanjakova v. Holder, because in this decision, Judge Posner described 3 different types of harm that constitute persecution. In our view at NIJC, this is pretty much the best definition of persecution you can find. You will find many, many different definitions of persecution in the Seventh Circuit talking about, you know, imprisonment with this type of harm is persecution, or imprisonment with this type of harm is not persecution. We wouldn't recommend getting bogged down in all those various examples. Stick to this Stanjakova decision as the clearest and best definition of what constitutes persecution. And so what Judge Posner said is he broke it down into 3 different types. And he said, you know, one type of persecution would be significant physical force against a person's body. This is the type of harm we all think about when we think of persecution, somebody getting beaten up or tortured, physically harmed. Then he said the infliction of comparable physical harm without the direct application of force can also constitute persecution. So here the example he provided was somebody being thrown in jail and not being given food or water for a period of time. There's no direct application of force, but the physical harm is comparable to the first example, to the significant physical force. The third example is non-physical harm of equal gravity. And this is a really useful definition because remember, anytime you can establish past persecution or try to establish past persecution, you want to do so in case you can get that rebuttable presumption. So non-physical harm of equal gravity, as Judge Posner discussed it, could include threats. Death threats can constitute persecution if they are credible and serious and imminent. But he also talked about how not being able to practice your religion could also be non-physical harm of equal gravity. These are two really useful examples. A lot of our clients have repeatedly been threatened with death, but maybe they fled before the threats were actually acted on. That can still constitute persecution. But we also make arguments for other non-physical harm of equal gravity. So for example, in the context of a gender identity or sexual orientation case, we might argue that somebody who is not able to be out in their community safely, that would constitute non-physical harm of equal gravity. We've argued that a child who was unable to attend school for some reason because of related to his persecutors would constitute non-physical harm of equal gravity. So again, keeping in mind you want to argue past persecution wherever you can. This is an area of the law where you can be creative in trying to make your arguments as to past persecution. A few other things that are important to keep in mind. One is that the harm constituting persecution can be less for a child than for an adult. And so this means that even if your client is now seeking asylum as an adult, but suffered harm as a child, you want to reference your client's age at the time that persecution occurred and argue that age needs to be taken into account when determining if that past harm constituted persecution. And finally, it's very well established that when determining whether harm rises to the level of persecution, an adjudicator must consider the harm in the aggregate. The adjudicator cannot look at incident 1 separately from incident 2, separately from incident 3. And again, you want to argue past persecution whenever you can. So even if there's an incident that you think may not rise to the level of persecution on its own, you want to make sure you present that claim because considered cumulatively with the other harm, it could very well be found to rise to the level of persecution. So we're going to move back to our hypotheticals again of Cristopher and Norma and take a little time to think through what are the facts here that would be useful when trying to make past persecution arguments for Cristopher and for Norma. So we're going to do another poll here. We're going to start with Cristopher's claim. So take some time and think through what are the facts here that you think are relevant when determining if Cristopher established past persecution, and what would you argue to the adjudicator? All right, we're going to close the poll, and I do see that we had a question asking to move back to the facts. Unfortunately, we can't swivel back and forth between the poll and the facts. After we get through this poll, I'd encourage you to pull the handout. You can look at the PowerPoint in the handout, and then you can have the hypothetical with you as we go through the poll. Okay, so we're going to share the results here. All right. So it looks like about 89% said the gun to his head is an important fact, 85% said the graffiti, 74% said his age, and 74% said the identity of the persecutors. So we'll talk through these really quickly. So the gun to his head is probably a very obvious one, right? The fact that he had a gun held to his head is something very significant, especially when you know, it's being in the context of being physically harmed as well. So the gun to his head shows it's considered a death threat. And that would be a pretty powerful piece of evidence. The graffiti and stalking by the militia are also potential things to keep in mind as well. So on their own, having graffiti on your house and being stalked may not constitute persecution, although given his age, which is, I know, another answer here, we might make that argument. However, when considered cumulatively with the other harm, this is where you'd want to argue that looking at this all together, especially if we're arguing that this is a pro-government militia that may be connected to the police, cumulatively, that this could add up to persecution. His age at the time is definitely a critical one here, and we really want to emphasize that to the adjudicator as to how old he was, and probably particularly as a child, you know, sorry about that, as a child, how that impacted him. And then finally, the identity of the persecutors. This is an interesting one because, of course, we want to keep the elements separate, and who the persecutors was is important for the next prong, the next element, which is were the persecutors the government or an entity the government is unable or unwilling to control. However, the identity of the persecutors can also be important to the persecution analysis because it can show the likelihood that they can actually inflict the harm. So here we have a situation where Cristopher was beaten and he had a gun held to his head. And the fact that the gun was being held to his head by the police, we'd argue is significant because the police, particularly in Venezuela, may have particular power to actually harm him with that gun. Likewise, the fact that the graffiti and the stalking was by a pro-government militia is important to establish the persecution element, because you would have the power of the pro-government militia behind their actions. And you could, for example, try to gather evidence to show that this should be considered a threat, that, you know, a pro-government militia taking these particular actions is consistent with threatening behavior by this militia, and use that to reinforce your past persecution argument. All right, we're going to do the same thing now for Norma. So take a quick look at Norma's facts before we move to the poll. And we'll give you about a minute to answer the same question for Norma. All right, about 5 more seconds. Okay. So about 70% said Norma's childhood abuse, 80% said Norma's abuse by Carlos, 75% said Carlos's threats against Norma's child, 95% said the threats from the gang members, and 58% said Carlos's witnessing of a gang murder. So we'll talk through these a little bit. I'm really glad to see that a lot of folks chose Norma's childhood abuse as evidence that they would want to reference. I think this is really important. So very frequently with many of our clients, the reason they ultimately fled to the United States is not the same as all of the other bad things that happened to them in their home country before they ended up fleeing. People leave their countries for very different reasons, and many different reasons, and often multiple reasons. But that doesn't mean that other things that happen to them in their home country aren't also a basis for asylum. And unfortunately, we often do see individuals who have experienced abuse at various points in their life. And we want to make sure we're referencing all of that past persecution in their claim, even if it's not ultimately the reason that they fled. So the fact that Norma was abused in her home and then experienced more abuse with Carlos, those are things that we would want to make sure that we were emphasizing in the case in the past persecution claim. Norma's abuse by Carlos, as well as Carlos's threats against Norma's child, would fall, in our view, very clearly into past persecution by Carlos. Obviously, the abuse of Carlos against Norma, but also it's very common in the context of a domestic violence case for an abuser to use a child as a means of controlling his partner. And so we'd argue that the threats against the child were part of the abuse against Norma. And then also Norma has this third claim, right, related to the thing that she fears may happen to her family because of her relationship to Carlos. And so the threats from the gang members against the whole family would include threats to Norma. And finally, Carlos's witnessing of a gang murder here is, in and of itself, that is past persecution, we might argue, but it's of Carlos, of course, if there were any threats that occurred in the context of him witnessing the gang murder. And Carlos here is not the client. But we might argue that that particular piece is relevant to the past persecution claim because we could argue that under country condition evidence would show that gangs have a policy or a practice of harming those people who witness their activities and the family members of those activities. So you might utilize the fact that he witnessed the gang murder to further substantiate and support the fact that the threats the gang made against the family are considered past persecution or should be considered past persecution. All right, so we're going to move now into the third element. So the third element here is the persecutor. So in order to establish asylum eligibility, you don't have to show that the persecution was by the state itself, but you do have to show that either the persecution was by a government entity or an entity the government is unable or unwilling to control. And so here we have an example of many different types of governmental entities or non-governmental entities that the government is unable or unwilling to control. And a lot of times these overlap. So in some cases, especially those involving gang violence from Central America, we might argue that the gang is both an entity the government is unable and unwilling to control, but also in some cases, the gang and the government are so interchangeable because of corruption and collusion that the gang should be considered the government in this particular instance. So these are strategic determinations you have to make on a case-by-case basis, and that we are very happy to work with you to figure out. If you can argue that the persecutor is a governmental entity, great. That gets you a step further along the path. But if you can't, it's okay. You just need to show that the government is unable or unwilling to control the persecutor. All right, so now we're going to move into what I think is very often the most difficult part of an asylum case nowadays, which is the burden of proof for Nexus and the particular social group. So in order to establish asylum eligibility, you have to show that the protected ground was at least one central reason for the persecution your client suffered or fears. It doesn't have to be the only ground, but it does have to be one of the central grounds, one of the central reasons. It can't be ancillary to the protected ground. At the same time, the case law very well recognizes and says is well established that persecutors can have mixed motives, and that's okay. You don't have to establish that the protected ground was the one definitive reason that the persecutor was targeting your client. There can be multiple reasons, and as long as the protected ground was not ancillary to other reasons, then your client can still be eligible for asylum. Finally, the case law recognizes that circumstantial evidence is more than sufficient to meet your burden of proof, because persecutors very rarely provide notes saying, I'm persecuting you for this reason. And so circumstantial evidence can be perfectly fine to establish the nexus between the protected ground and the persecution. So this little graph here, this pie chart, is an example of the types of evidence that we typically look to so that we can establish all of the various ways to show the nexus between the protected ground and the persecution. So we're going to want to look to country condition evidence as strong circumstantial or indirect evidence of the reason for the harm. We're going to want to look to context and the modus operandi of the persecutor. Does the persecutor have a habit of doing X, Y, Z? And does your client fall into that particular category? And then, of course, you're going to look to direct evidence. So these are the actions and the words of the persecutor towards your client. This is obviously the most powerful evidence you can have, and these are the things you really want to dig into with your client. What did the persecutor say when he was harming you? What was happening at the time? How did the persecutor act when you said X, Y, Z? Because you want to draw out those direct actions and those direct words. But if you don't have much of that, it's okay. Circumstantial evidence can be fine. So the nexus is the connection between the persecution and the protected ground. And again, we just like to emphasize here again that persecution and protected ground and nexus are three separate elements. Whether your client was persecuted is separate from the question of why your client was persecuted, which is separate from the question of whether the persecution was on account of a protected ground. So we'll want to keep those in mind throughout. Which takes us to the last element here, which is the protected ground itself. So we try to avoid using the word political asylum, because even though that's the traditional way that asylum was often referred to as political asylum, nowadays the vast majority of asylum seekers we are seeing are not seeking asylum for political reasons. They are generally seeking asylum based on this fifth protected ground, membership in a particular social group. So to go through these very quickly, race, religion, and nationality are all very self-explanatory protected grounds. They have broad meanings. They often overlap. We don't see huge numbers of cases with these particular claims, but we do see them sometimes. Most of the claims we see fall under the political opinion or membership in a particular social group categories. Political opinion is also fairly self-explanatory, but it's important to keep in mind that a political opinion claim can be based on your actual or imputed political opinion. So you can be an actual political dissident who's in the streets protesting, or you could be the child of a political dissident who is apolitical, or you could be somebody who just happens to live in an area that's controlled by a particular rebel group or militia, and the views of that rebel group or militia are imputed to you by the government and you're targeted for that reason. Actual or imputed is okay. The membership in a particular social group, like I mentioned, is one of the most common and most complex bases for asylum, and it's one of the bases for asylum that's gotten the most controversy in recent years, as the administration has really attempted to crack down on the ability to get asylum under membership in a particular social group. And not just this administration, the Obama administration has tried as well to crack down on this particular ground as a basis to restrict access to asylum in the United States. We have an entirely separate training and webinar and practice advisory on particular social group claims, because the case law has evolved considerably over the past 10 years, and it's particularly complicated because there's a split between the Seventh Circuit and the rest of the country. We're not going to get into all of that today. We're just going to very quickly provide an overview of the difference between the case law here in the Seventh Circuit and the case law at the Board of Immigration Appeals, which has generally been accepted by the rest of the country. So membership in a particular social group is not defined in the statute or regulations. In the 1980s, the board defined it in a case called Matter of Acosta. And in that decision, the Board of Immigration Appeals said to look at the other protected grounds, race and nationality are two characteristics you cannot change. Political opinion and religion are two characteristics you should not be required to change. Therefore, to be a membership in a particular social group, you either have to be a group that is based on a characteristic that you cannot change, like race and nationality, or that you should not be required to change, like political opinion and religion. That was the definition that was utilized for about 2 decades, until a set of case law came out in 2008 and then in 2014 that really tried to restrict the membership in a particular social group definition. And the definition was restricted by the board and the Attorney General adding 2 additional qualifiers to the definition. The board said that particular social groups have to be particularly defined and socially distinct. And the way this has worked out now is under Board of Immigration Appeals case law, the board has frequently said that particular social groups can't be overly broad. Society has to recognize the group as a group, that being former something, which is automatically immutable, is not enough to be a particular social group, and that groups can't be overly diverse. The Seventh Circuit has either explicitly or implicitly rejected all of these changes and really sticks to an immutable characteristic test as was first established in Matter of Acosta. So this is an area where it's really important to keep in mind what the board case law is, but that's not what you want to cite in your case. You want to stick to Seventh Circuit case law because that's what's most important here when you're presenting a claim in the Chicago Immigration Court. Of course, if you're practicing elsewhere, you need to pay attention to the law in your particular circuit, which may be slightly different from what the board has presented, but is going to be most likely very different for the Seventh Circuit. Here, we're focusing on Seventh Circuit case law and what you need to present here at the Chicago Immigration Court. All right. So we are going to move into, I think, our last poll of the day, which is going to be a question about which protected grounds do we think fit best here. So again, take a look again very quickly at the hypos before we move into the poll. And we'll start the poll first for Cristopher. So what protected grounds do you think might apply in Cristopher's case? All right, 5 more seconds. All right, we're going to close the poll. And we'll share the results here. All right, so it looks like most of you thought that there was a political opinion claim here for Cristopher. About 20% thought there was a nationality claim, and then 58% and 38% both thought particular social group claim, but there was some disagreement or possibly confusion about both, whether there should be a particular social group claim based on having made that report to the police station, or a particular social group claim based on being a family member. And understanding there were multiple answers here, so you may have chosen more than one. So walking through these very quickly, I think the easiest one here to look at is the political opinion claim. Now, we didn't specify in the answers whether this would be a imputed or actual political opinion claim. And I think here it's a little unclear because we don't know much more background about Cristopher, right? Was he involved in anti-government political activities in the past or anything like that? But very clearly here, there seem to be some at least imputed political opinion imputations here. So, you know, he's leading an anti-governmental protest, the police hold a gun to his head, the word traitor is written on his house, all implying that there's some belief that he's against the government. So I think that's a very clear one here, and probably the primary claim based on these facts that we would present. The nationality claim, I think, is a little trickier. I don't think here, based on these facts, I would necessarily say there's a nationality claim. Cristopher, of course, does have a nationality. But the question is whether he was targeted on account of his nationality. And there's nothing here, I think, based on these facts to indicate that his nationality itself was a reason that he was being targeted. So although he has a nationality, he's part of that particular group, he was not necessarily being targeted for that reason. And so that would not necessarily give rise to the underlying claim. The particular social group claim is also a little tricky here, again, in part because we don't have all the facts. I think we could definitely make a particular social group claim. We probably would want to know a little bit more about the report that he made to the police station. Was this the instigating factor and why traitor was written on his house? Because he made this report to the police, did this give rise to more beliefs that he was against the government? Or is there a policy of the police or the pro-government militia of targeting people who make police reports? The same with the family membership. Right now, I don't think there's anything in these facts to indicate that he was being targeted for his family membership. We know that his mother was helping him, but we don't know if anyone else in his family was politically involved or if he was specifically targeted because of the family he belongs to. Now, again, this is where it's really tricky and you want to keep your elements separate, right? So in these cases, Cristopher has a nationality. He belongs to a group related to his family, certainly. That's a group that's probably recognized in his community. He's probably recognized as being the son of his mother and belonging to this particular family. But if those are not the reasons he was targeted, then those are not protected grounds that give rise to a claim in his case. So those are the separations and the things you want to keep in mind. We're going to move now into the last poll for Norma. And we'll give you all about a minute. All right, 5 more seconds. All right, we'll go through the answers on this one. And this one is a little trickier. So if you found this one confusing, you're probably not alone, in part because some of the case law has been fairly complicated regarding domestic violence-based asylum claims. So we have 5 different potential particular social groups here, and it's entirely possible that other protected grounds could apply, but based on the facts we have here, we see this generally as a particular social group case. So in our view, in a case like this, we would likely present multiple particular social groups. I think at its base, one of the primary broadest groups we would present would be Salvadoran women. Norma is clearly a Salvadoran woman. This is a group that she belongs to, so she's part of this particular social group. And we'd argue that the evidence would show that she was targeted for this reason, that she was abused in her home and by Carlos fundamentally because her family members and Carlos believed they could harm her because she was a woman in El Salvador, and they would be able to get away with it, that it was maybe acceptable, that maybe in some cases it was deemed required of them to treat her this way if she wasn't behaving as a woman should under gender norms in her particular community. And so we'd really look at the country condition evidence and the context and the circumstances to argue that she was being targeted for that reason. Family membership and relationship status also seem likely to be particular social groups we'd argue here. Family membership probably because of the gang threats that Carlos received and that she received indirectly. So the idea being that she was being targeted by the gang because the gang was seeing her as a member of Carlos's family and was going to target the members of Carlos's family in order to get to Carlos. Relationship status, though, can also be a big part of domestic violence related claims because often the abuse, whether it's familial abuse from a family member or from a spouse, is occurring because the family member believes that within the context of the family or the relationship, that family member has the ability and the authority to harm that person with impunity. And so again, we look at the words that Carlos was using. Did he say, you have to do this because you're my wife? I get to do this because I'm your husband? The same with her family members. You know, if it was her father abusing her, was he saying, you know, you're my daughter, you have to do this, or I'm your father, I can do this to you, that sort of thing. Gender norms got the smallest percentage here, but actually the violation of gender norms is a very common particular social group we present in these cases, again, depending on the specific facts. Very often in these domestic violence type claims, we will see the abuser targeting the spouse because she's not acting like he thinks a woman should, right? Maybe she wants to work and he doesn't want her to work. Maybe she doesn't have dinner ready when he comes home from work and he thinks she should. Maybe he wants her to behave in a certain way. He wants her to be available for sex when he wants it. He wants her to ask him for money and not earn money on her own. All of these various gender norms. And if you can tie the abuse to the violation of those gender norms in the eyes of the persecutor, that's going to be some good evidence that she was being targeted for violating or disobeying those gender norms. The last particular social group, which actually got the highest percentage here outside of the Salvadoran women group, is actually the one that we would not want to present. And this is because this is a circularly defined social group. And it's problematic for 2 reasons. First of all, case law is quite clear now that if you define a particular social group by the harm suffered, it will generally be rejected as a non-viable social group. But the primary problem here is because it's circular, you're not going to be able to meet the nexus element. So Norma is not being targeted with domestic violence because she suffered domestic violence, right? That's a circular definition. Someone is not being harmed because they were harmed. The domestic violence is occurring for other reasons. Now, if there are certain instances where past persecution can give rise to an entirely different type of future persecution claim. So for example, there's a decision in the Third Circuit that talks about a former child soldier who then was being targeted in the future because he was a former child soldier. And the argument was, yes, when he was a child soldier, he was persecuted as a child soldier, but the future persecution is different. So in that case, it's okay to have the social group be based on being a former child soldier because it's not circular. Here, if we're arguing that Norma suffered persecution by Carlos, if the persecution itself is in the social group, then you're not going to be able to establish Nexus because it's too circular. So that last particular social group is one that we would strongly advise that you not include. We don't want to reference the harm suffered in the social group itself. All right. So we have now gotten through all of the asylum elements. So we're just going to touch on a few final considerations before we move into a really quick overview of first steps, and then we'll be done with the training for today. So a couple of other issues to keep in mind in your case as you're moving forward. So we talked about how these are the 5 asylum elements that you have to meet, but keep in mind asylum is a discretionary form of relief. And then there are also life changes that can come into play that could impact your client's situation. And so you always want to keep an eye out for those things and circle back with NIJC. Anytime there's any life changes in your client's life, we want to know about them, talk with you about them, and figure out if they have any impact. So there are certain events in your client's life that could make your client eligible for other relief. If your client is a victim of a crime, if your client gets married, things like that could affect your client. And so we want to talk about those things before they happen, ideally, or as soon as they happen. If your client is a victim of a crime, let us know right away. We want to talk about how that may impact your client's immigration eligibility. If your client's contemplating getting married, we ideally want to talk about that beforehand because it could impact various parts of your client's claim, or it may not make them eligible for any other relief, but they may be under the misperception that it will. And so we want to talk about that in advance. There are other things that could really compromise eligibility in a problematic way. So crimes are a big one. If your client has any law enforcement contact whatsoever, even if it's driving without a license, anything like that, we want to know about it right away. Especially under this administration, there are a number of pending regulations, notice of proposed rulemaking that we're waiting to be finalized that may make it much more difficult to get asylum, even for the smallest law enforcement interaction. They're not finalized yet, but they could be in the very near future. So we need to know if that happens so we can strategize with you on options for your client. Travel is one that also comes up a lot. We used to say as long as you weren't traveling too close to the southern border or the northern border, it was generally okay as long as your client was, not driving without a license and that sort of thing. With immigration raids and ICE stops and things like that, it's become a lot more dangerous to travel than it used to be. So if your client is contemplating traveling anywhere outside of, Indiana to Illinois, let us know before they travel and we can talk through the risks. Your client absolutely cannot leave the United States, the continental United States, while their case is pending, or they may not be able to get back into the United States. Finally, this last slide here, regulatory and policy changes. We could do an entire training just on everything that has changed in the past 3 years, and quite frankly, in the past month. There have been so many changes to the asylum system, so many ways that this administration has tried to attack and undermine the asylum system. Fortunately, right now, because of litigation and because many of the proposed rules have not been finalized, there has not been a tremendous change in the way we present our asylum cases here in the 7th Circuit yet. So you'll hear a lot of very bad news. You'll hear a lot of bad media coverage about the bad changes that have come from the Trump administration towards asylum seekers. For the most part, the biggest way they've impacted our clients is in delays and uncertainty and rescheduling and just bureaucratic hurdles and confusion in the immigration court. But again, things could change at any time. So one of the best things we recommend is that if you take a case from us, read our cover letter that we give to you regarding your client's eligibility for relief closely. It will specify different deadlines and different things you have to keep in mind. And then keep a close eye on NIJC's website and our NIJC Pro Bono newsletter. When there are major changes in law or policy or procedure, we put them up on our website. We have FAQs and other explainers for you so you know whether or not is this a change that affects my client now? Could this affect my client in the future? One of the most recent changes has related to asylum-based employment authorization eligibility, the timeline for when you can apply, and how much you have to pay for an EAD, an employment authorization document application. It's incredibly confusing because there were rules that were supposed to go into effect, some did, then there were multiple injunctions. And so to understand what's going on, you really need to have a close eye on all of these changes that are happening on a day-by-day basis. That's what we're here for. Don't hesitate to reach out, take a look at our website, utilize all of our materials there. We want to make this as painless as possible for you, understanding that this is quite a painful process right now, given the current immigration environment. So I'm going to turn it over to Dahlia. I know we do have a couple of questions. We will try to answer those at the end if we can, and if not, we will email you directly if we weren't able to answer it today. So Dahlia, whenever you're ready.
There we go. Thanks, Ashley. So in this last section, I'm just going to briefly go over, some of the first steps that you'll want to take when you accept one of our pro bono cases. I'll be going through this fairly quickly, but everything that I talk about today will be discussed in a lot more detail on Wednesday when we talk about preparing and presenting your case. Let's see, the first thing is, so the asylum system has a few different moving parts to it, and the case that you take on could be in a couple of different postures. So there is the affirmative side of things, which is if your client is not in removal proceedings, they're not going to immigration court. And so in that case, you would file an asylum application with U.S. Citizenship and Immigration Services at the asylum office. Many more of our clients are in a defensive posture, which means they have received something called a notice to appear, and they have to present themselves at the immigration court. Immigration court is housed within the Department of Justice. Then we have the Board of Immigration Appeals, which, as Ashley mentioned, is the administrative appeals body for immigration court, and above the immigration appeals, we have the circuit courts. So in where we are located right now in Chicago, it would be the 7th Circuit Court of Appeals. If you're elsewhere, it would be whatever your local circuit is. So again, there are several moving entities involved with the asylum process. So at the adjudication level, if your client is in a defensive posture, meaning at immigration court, then the Executive Office for Immigration Review is the adjudicator. Immigration Court and the Board of Immigration Appeals both fall under the Executive Office for Immigration Review. On the Department of Homeland Security side, so Immigration and Customs Enforcement is part of the Department of Homeland Security, and there are 2 branches of ICE that you may encounter with your client. One is the Office of Chief Counsel, and these are the attorneys who represent the government in immigration court. So if you go to immigration court, the attorney opposite you is going to be from ICE. There's also ERO, which is Enforcement and Removal Operations. They are the folks who enforce immigration laws, arrest folks, things like that. If your client may have ICE check-ins and other issues like that to deal with as they move through their case. USCIS is also part of the Department of Homeland Security, and so if you're in the affirmative posture, they are the ones that are going to be adjudicating your case. And Customs and Border Protection is who your clients will encounter near the border if that is where they enter the United States. If your client is an unaccompanied minor, they will likely be placed into the custody of the Office of Refugee Resettlement. And of course, the asylum seekers and their families are involved as well. So the first thing that you're going to want to do when you take on a case is review the file that we send you. And in that file, we'll have a cover letter that lets you know what the procedural posture of your case is. So whether you're at the asylum office or the immigration court, we will note any important deadlines and give you a list of the forms that you need to file. Among the first forms that you should file is your appearance, which if you are at immigration court you'll have to complete an e-registry process and file form E28, that's your notice of appearance. And if your client is at the asylum office, then you will want to file a form G28 with the Chicago Asylum Office. It can get confusing because they're both form 28, but E28 for court and G28 for USCIS. Another thing that you're going to want to do is make sure that you put all of the deadlines in your calendar. They can often sneak up on you when you are not realizing it, and some of the deadlines can be, very far in the future. So it'll be good to have those noted so that you don't forget. Some of the important deadlines are going to be obviously when court hearings are, but also when your client is eligible for employment authorization and when they need to renew employment authorization. Work permits are really essential for many of our clients and allows them to, survive while they're going through the lengthy process of applying for asylum. You'll want to check the immigration court's automated system on a regular basis to see if your hearing is going ahead, if there have been any changes. You can also file a Freedom of Information request with USCIS to get your client's immigration history, which can be really helpful. That way you can see what information the government is going to have when you go to immigration court. And then you want to call your client and get started building a relationship and getting to know them and their story. A couple of things that you're going to want to keep in mind as you're beginning case preparation is that you're going to need to produce 3 documents. One is the brief. You're going to have an affidavit from your client that outlines everything that's happened to them. And an annotated index, which lists all of the supporting documents that you're submitting to the court. And we'll talk more about this on Wednesday, but some examples of supporting documents would be country conditions evidence, expert affidavits, any police reports or witness statements or anything that might be relevant to your client's asylum claim is all going to be important to include. Another thing to note is that things are a little bit tricky in terms of logistics and scheduling at the moment because of the COVID pandemic. So this slide just sort of is a general overview of the way things seem to be working right now. So the Asylum Office has resumed conducting interviews as of June 2020, and there are some precautions that they are taking to reduce the risk of transmission. And in July, the Chicago Immigration Court started hearing non-detained merits cases. So these would be your full asylum hearings. There are COVID restrictions in place, but preliminary hearings are not going ahead at the moment. One of the difficulties that the pandemic seems to have caused is that hearings are often rescheduled or canceled on very short notice. So it is going to be important for you to continue to check the automated system to make sure that your hearing is going ahead as planned. So that's pretty much it for first steps. We'll be addressing all of this in a lot more detail on Wednesday. We'll be talking about what you need to file for a successful asylum case, giving you tips on working with asylum seekers, as well as what to expect at the immigration court and the asylum office in a lot more detail, and some tips for case preparation under the current COVID restrictions.
Thanks to all of you, and please excuse the Thursday typo on the PowerPoint here. The next training is Wednesday, not Thursday, so please join us on Wednesday, not Thursday, for the second part of the training. At this point in time, we are finished with the training for today. So a couple of final housekeeping matters before we close things out. First, we would love any feedback you have. As I mentioned, this is our first full asylum virtual training we've done. We've done bits and pieces of this in the past virtually, but doing this virtually for our entire training is a little bit of a switch for us. So we'd love any feedback that you have. In addition to the QR code here, I am going to put in the chat the link for the survey, the evaluation, if you wouldn't mind filling it out. For those of you who are eligible for CLE credit, we will be sending the CLE certificate to you later this week. As I mentioned, we'll be sending the case list following the training on Wednesday if you're interested in taking on a case. And we are also here if there's any remaining questions before we sign things out today. We know this was a lot of information, but fortunately we have a lot of other materials on our website. So if your hand is tired from taking too many notes, we have a manual on our website where you can access many, many more details. And the fun part of the training, the nuts and bolts of actually how you work on these cases, how you put things together, how you go before an asylum officer or an immigration judge, will be talked about at our training on Wednesday. If you haven't signed up yet, we do still have slots available. So Dahlia and I will remain online for a few more minutes in case there's any additional questions. Otherwise, thank you very much for participating, and we hope to work with you soon. We did have a question about a link for the Wednesday training. There's a separate sign up for the Wednesday training. So if you did not separately sign up for Wednesday, you will need to separately sign up for that through our website. If you did sign up and you're waiting for approval, rest assured you'll be approved before Wednesday and then get the link at that time. All right, well, it looks like there aren't any more questions. So thank you again, and we look forward to speaking with you on Wednesday.